How can real estate be inherited?
Now the question is inheritance very easy?
So, what can be construed as an ancestral property?
Before 2005, women were being denied that right of co-partnery in what we call ancestral property.
So, there are, you heard of these strange cases where people have kicked their old parents out of the house, they've taken over property. So, sometimes I think people get scared. Welcome back to another episode of PropSutra with Balaji Rao. PropSutra is presented to you by Prop News Time. In this week's episode, we discuss succession planning with real estate properties. Welcome to the show, sir.
Thank you.
How can real estate be inherited?
See, real estate you can get in three ways. Either you buy, or it is gifted to you, or you inherit it. Okay. So inheritance is actually the process by which you get what we call property that belongs to the older generation, usually the parents, and that is inherited by you by transmission, what we call. On the death of that parent or grandparent or a relative, you get that property. So this is one of the three ways by which you can get property in your name. Now the question is inheritance very easy? It is easy as well as complicated based on how well you have structured and formalized the process before your demise. You understand?
Yeah.
See, for example, the most two divisions is, does the person who owns the property,
Yes.
does he die with a will or without a will? That's the first two divisions. Right. Because if he dies without a will, it is called intestate.
Okay.
Then naturally you will need to approach the court with some sort of a family settlement where people have decided in what way it will be happen, either by way of law or mutually settled amongst the inheritors.
Okay.
If you die with a will, it becomes far more clearer what your intentions were to do with the property.
Okay.
Okay. So when you have a will, then it is easier for the court to interpret or your inheritors to interpret what exactly you wanted to happen to the property.
Okay.
Okay. So it is not a very easy path. It can be made easy with the help of experts, legal experts, who will guide the people owning the property what they should do.
Okay.
So there are various nuances to it, and we can discuss it during this episode as we go along.
So can you walk me through what happens generally when somebody leaves a will behind?
Okay. So let's take that division first. When you leave a will behind, you're clearly stating what your desire is, what your intention is to do with the property. Now, then the question comes in whether the property has been self-acquired.
Okay.
Or has it been ancestral property that has coming to you from generations? Okay. If it is ancestral property, then as per the Hindu Succession Act, as per the Hindu law, which applies also broadly to your Buddhists, Jains, Sikhs, and it's different for the Muslims and the Christians. So, as per the Hindu Succession Act and as per the provisions of the Indian Succession Act, what will happen is it will be going as per that law.
Okay.
Okay. So if it is ancestral, then naturally it should be divided equally, as they say, amongst all co-partners. And this is especially true after 2005.
Okay.
Before 2005, women were being denied that right of co-partnery in what we call ancestral property, or even in Hindu undivided family assets.
Okay.
Okay. It was only the male heir who was getting it.
Okay.
And the descendants of the male heir.
All right.
But after 2005, it is not so.
Okay.
So as of now, everybody gets an equal share. Whether you're married or unmarried, whether you're a son, daughter, it doesn't matter. All the heirs, the class 1 heirs, it will be divided equally.
Okay.
Okay. It is a bit different for the Muslims and the Christians. So that you should go to experts to discuss it. But there are laws which tell you how it gets divided if it is ancestral property. If it is self-acquired property, that means the person who owns the property has acquired the property
Okay.
during his working career, then he has a right to do whatever he wants with it,
Okay.
especially as per the Hindu Succession Act. He has a right to do whatever he wants with it.
Okay.
He can donate it to charity. He can give it to one inheritor. He can give it to a stranger. He can do whatever he wants. But ideally, in a will, he should be clear why he is doing that.
Okay.
Otherwise, it can be disputed by the legal aids
Okay.
to say, how come it has happened this way?
Okay.
Okay. So usually when you're writing a will,
Yes.
it should be very clear as to why you have chosen that path.
The
That your
reason.
heirs don't need your property, or you always wanted to will it to this organization or to this charity or to this person who has served you towards the end. So whatever might be the reason, it should be clear.
Okay.
Failing which, it will be disputed.
Okay.
Especially if it is going to come as a surprise to the heirs.
Understood.
Okay. So then you have a right to divide it whichever way you want,
All right.
because it's your self-acquired property. And usually most wills which should have an executor.
Okay.
The executor of the will ensure that your desires, what you have encapsulated in the will, is carried out.
Okay.
So it's his job. Usually he shouldn't be a beneficiary of the will.
Okay. It should be
So it says
somebody
he's a
else.
neutral person, might be a lawyer, might be somebody known to you. He will execute the will in the way you have told it should be divided, the property.
So what can be construed as an ancestral property?
Well, ancestral property, as per its very definition, is something that has been coming from generations.
Yes.
Okay, so it might belong to your father, it can belong to your grandfather, it can belong to an earlier generation, usually up to 4 generations, whatever has been the property. That which you have inherited also, that is ancestral property. But if you change the mode of the ancestral property, then it disappears.
What do you mean by that?
Because if I sold off the ancestral property and bought something else,
Okay.
then it is assumed that I've been able to sell off the ancestral property or the HUF property sometimes with the approval of all the other co-partners, and I've changed the character of the asset. So then it becomes not ancestral. I might be able to dispose it of whichever way I want.
Then it changes to self-acquired.
Literally, yeah.
You spoke about an executioner for the will. How do I assign somebody that role, and how do I ensure that my will is executed as per my wishes?
No, see, it's an executor for the will. And the executor is somebody whom you trust, knows why you have written the will the way it is.
Okay.
He might have guided you. So he might be a lawyer, as I said, a family lawyer, or it might be an elder in the family or a knowledgeable person of the family who knows what you wanted. And he's not a beneficiary, as I remain.
Right.
It's better if he's not a beneficiary.
Right.
So that even if it is disputed, then he is a witness to the fact that this was your desire, that this is the way it should be, not equal. But, bulk might go to somebody and lesser amount might go to somebody else.
Okay.
So that's an executor. So how do you choose? Usually you will be depending on people who will advise you,
Yes.
or you can choose a professional lawyer to be your executor.
When do I need to get a probate of a will?
See, any will, one, if it has been executed in the 3 erstwhile presidency towns, as we call it,
Okay.
which have been Kolkata, Chennai, and Mumbai.
Okay.
These were the erstwhile presidency towns. Any will that is executed in these towns, or it is executed elsewhere, but an immovable property is located in these towns.
Okay.
You're leaving an apartment or land or whatever you have as immovable property in these 3 towns, then it needs to be compulsorily probated.
Okay.
That means you have to go to the court to give its sanction to the will, saying it's valid.
Okay.
Okay. So that is a process of probation, which usually you'll go through a lawyer to get it done. Might take you 6 months to a year. It'll be a little bit expensive, and it has to be done.
Okay.
Besides these exceptions, all other wills need not be probated unless there is a dispute.
Okay.
You understand? If there is a dispute, then you will have to end up in court.
Okay.
Because you'll say, this is the will, this is the dispute, how do you settle it down?
Okay.
Okay. Otherwise, all other wills, you can go without probate also to get your desire done.
All right. So just to reiterate, if my property is in Mumbai, but the will is being executed in Ahmedabad, I will still need to get a probate.
Absolutely.
Because the property is
in the Mumbai town, city.
Okay. To avoid a dispute, does it help to register the will?
See, registration is a process in law which just tells you that you have signed the will.
Okay.
It helps quite a bit. So there are two things. One, you can notarize it or you can register it.
Okay.
Even a notary is good enough to say that, yes, the person who made this will came in front of me and signed it after identifying himself.
Okay.
Okay. The same thing the registrar does.
Right.
The registrar is a higher level because he's a government authority, he's a government servant.
Right.
Whereas here, it is more of a public person who is renowned for his integrity, who is made a notary public. Okay. So you can get it notarized or you can get it registered. It only means that, yes, I have signed the will.
Can succession planning happen without court intervention?
Yes, as I explained to you, where you cannot really avoid it is when your property or when you're signing the will in these three places.
But let me rephrase. If I want to avoid court intervention, how should I go about it?
Then you don't have the immovable property, no? So one way is to do it is, see, like even in these places, in some cases, what is advised is, suppose I don't have any immovable property.
Mm-hmm.
Why? Because I gifted it away or I put it in a trust, a living trust. So it has gone away from my ownership.
Okay.
Then what I'm giving to you are only stocks and shares and bonds and time deposits or fixed deposits or accounts, savings accounts, correct?
Okay. Yes.
So those, if you have nomination or joint accounts, you really don't need anything. You'll write in your will, as per the nomination I've given for each of these, or my surviving joint holder will be the owner of it.
Okay.
So you really don't require much of clarity on that. And you might not even get it probated.
What does it mean to put it into a trust?
That's a completely different this thing, where you take a property and put it in a trust, saying that the trust will have beneficiaries and the trust will then be the owner of the property, not you.
Okay.
You're the settler of the trust. The trust owns the property. There will be a trustee who will manage the trust and they will be beneficiaries of the trust.
Okay.
It's a whole new chapter.
Okay. How does it help to gift real estate?
Well, the person to whom you're gifting will always thank you because you're gifting something to him. Why people gift is they try to avoid probate and all these lengthy procedures while going through the inheritance process.
Okay.
But the risk of gifting is after gifting, you don't have any control over it. You can't get it back.
Right.
You understand? So you have to be careful to whom you're gifting.
Okay.
If you're sure the person to whom you're gifting, whether it's your child or a sibling or anyone, he is going to look after you or will be indebted to you.
Yes.
And he will do what you want him to do for the rest of your life, then you gift it.
Right.
Okay? Or if you don't need it and you believe you bought that property for your child, then you'll gift it.
Okay.
Because you really don't want it to hang like a Damocles sword on him, that if you don't look after me, the gift won't come to you.
Right.
So it depends upon your bond and relationship with your heirs, So is gifting good? Yes, it is good because it avoids the problems post.
Right.
And you're doing it during your lifetime. You're telling someone this is yours and this is yours and this is yours. So that there's no confusion in the future.
Correct.
Okay? Or nobody has to abuse you after your death, saying, I didn't get that, what you wanted.
Correct.
But it is bad because if you haven't kept enough for yourself, then you are now at the mercy of your heirs to take care of you. So it's a question for each person to figure out, do I trust my heirs?
Right. So there are, you heard of these strange cases where people have kicked their old parents out of the house. They've taken over property. So sometimes I think people get scared if I gift my property off. What would you recommend? What advice would you give them?
Well, if you're asking me what is the, risk mitigant in this sort of a thing,
Yes.
then what you should do is you should gift them.
Mm-hmm.
Write in the gift that the property is there, but I'll be occupying the property till my death. So it is coming with that.
Right.
And to be clear, you can also claim that you have a tenancy right on the property so that nobody kicks you out.
Okay. So that can be included to protect yourself.
It can be included in the gift, that the gift is coming with you inside.
How do I ensure my spouse is taken care of in case I pass away before?
No, that is you're assuming your spouse's name is not on the property, right?
Yes.
That you will it to him then, no?
Okay.
Or if you're gifting it, you will write that, as long as I or my spouse are still alive, we will be in the house. And we will not move out of the house, and we will enjoy tenancy rights or whatever it is in the house.
Right.
Till we pass, both of us pass away, and then only it will go to the heir.
So if I intend to gift it to my spouse, then essentially my spouse should also then have a will to ensure after my husband passes away that the property goes to whomever we want it to.
No, the recipient might not have a will if he doesn't. See, you will create a will where your name appears, remember that.
Yes.
In a very simplistic way.
Correct.
So if the spouse doesn't have his name, then he won't need it. If his name is already there, it will go to him. Right. First thing will always go to the joint holder, remember.
Okay.
Isn't it? So you will write in your will that it will go to the joint holder. Unless you're saying, excuse me, your share will go to someone and the joint holder will hold his share in something.
Okay.
There's a different issue.
All right.
But otherwise, it'll go to the surviving holder.
Here, there's a lot of confusion about a nominee on share certificates for cooperative societies. Can you help us understand the role of a nominee?
See, a nominee anywhere is a trustee.
Okay.
A trustee is somebody who's holding it in trust temporarily.
Okay.
Okay? It's not a permanent.
Okay.
So whether you nominate someone for your fixed deposit, for your savings account, for your shares, for your property, it is just a trustee.
Okay.
You're saying if I pass away, she is the nominee or he is the nominee.
Right.
Correct?
Yes.
So what happens? Why does it help? A society then doesn't have to search who is the legal heir. Okay. Because that might take a year. It might take years if it is disputed.
Right.
The nominee steps in till that time. It is settled.
Okay.
Okay. Now, if you write in your will, my nominee is the actual heir, then it becomes easier.
Okay.
But you might write in your will, the nominee is someone and the heir is somebody else.
Okay, that can be done.
Of course. So the nominee then doesn't become the heir.
Okay.
You have to specify in your will that the nominee is the heir. Only if you don't specify and you die intestate, then a court might construe that you might have wanted the nominee to be your heir, but that also is not given.
Okay.
Because you have died intestate, they will bring in all your assets and divide it the way it should be divided, as per a Succession Act.
Okay.
You understand?
Yes.
So nomination is not the end of the story.
Okay.
Nomination is just a temporary sort of a measure you have taken to see that none of your assets are in limbo.
Okay.
You understand? So the nominee holds it in place for that actual heir to step in.
Okay.
If you want the nominee to be the actual heir, then you might as well write that in your will.
Mention it very clearly. While on the same subject, can you help us understand what reverse mortgages are?
Reverse mortgages have not been very popular in India, but basically it works like this. I own a property, I have no mortgage on it.
Okay.
Okay? I don't want this property to go to my heirs per se. They don't need it.
Right.
But I have wealth but no income.
Right.
Because I'm sitting in the property.
Yes.
So I do a reverse mortgage.
Okay.
Where I mortgage it to a financial institution and they keep giving me monthly money. It's a reversal. Okay? And when I die, they will sell off the property to recover all what they've given me monthly.
Okay.
If there is any surplus, it will go to my heirs. It's simple.
What are your closing thoughts for this episode?
Well, see, death is inevitable, as they say. So I personally feel that most people who are seniors should look at what their succession should look like,
Right.
and knowing their own relationships, their heirs, their children, their siblings, their relatives, they should know how to ensure the transmission of assets. This is known as transmission, takes place in the smoothest way without any sort of a rancor or bitterness.
Okay.
So whether you call them and do it before your death, you call them and tell them what your will is, you gift it before with certain riders, or you leave it all through a will, whichever way you do it, it requires careful planning and thought. It requires you to focus on it, and it might require you sometimes to take the help of experts like lawyers or chartered accountants to navigate through the complex legal and tax issues.
Thank you so much.
You're welcome.
That's a wrap for this week's episode. Thank you so much for tuning in. Don't forget to like, share, and subscribe, and hit the bell icon for regular notifications. Until next week, thank you so much for tuning in.